Welcome back, members. In the concluding session of the 3 days intensive course on New Income Tax Act, we have a topic of interplay of allied laws vis-a-vis the Income Tax Act 2025. We have an eminent speaker, Advocate Ajay Singh ji, who will be taking with this topic. I request our committee member, Viral Shah, to briefly introduce him.
Welcome back, members. Pleasure to introduce the second speaker of the day, Ajay Singh, Advocate Ajay Singh. He is an advocate, Bombay High Court. By qualification, he is an LLB, LLM from Mumbai University. He joined the bar in the year 2000, and since then has been in the professional practice. He was associated with Chamber of late Shri K.R. Dhanuka Advocate, Shri B.V. Javeri Advocate, and Dr. K. Shivram Senior Advocate. He is practicing independently since 2015. His main practice of area includes domestic tax, search and survey matters, international taxation, transfer pricing and prosecution matters related to taxation. He specialized in drafting and appearing in writ petitions and appeals before High Court and SLPs before Supreme Court, drafting wills, agreements, consulting in real estate transactions, cooperative societies, and the list is quite long. He takes active parts in various professionals and social organizations. He's been editor of AIFTP journals, vice president of ITAT Bar Association, joint secretary of ITAT Bar Association, past president of the Chamber of Tax Consultants, and also the advisor of Students Committee of the Chamber of Tax Consultants. With this brief introduction, we welcome you, sir. I would now request C.H. Vijay JMG to please present a memento on behalf of the study circle. Thank you. The stage is all yours, sir. Thanks.
Very good evening to all of you. It is pleasant to be amongst you this evening, to meet friends, old seniors who have briefed me long back, and then again I am finding them here. It is always a pleasure to meet all of you here. Today's topic, a little weird topic, allied laws and interplay with income tax. When initially I was asked, I accepted, okay, chalo, padna ho jayega thoda, isi bahane. And I accepted, but later on when I started reading and working, I thought it is not getting over. And they had said allied laws. They never mentioned any particular law. Either you deal with PMLA, you deal with Benami law, or you deal with Black Money Act. They say allied law. So I thought from where to start and where to end. So this was a task. Anyway, we'll try to touch upon this. As an income tax practitioner, I had to deal with various laws when the appeal matters used to come to us, and over a period, and when I started listing out how many laws I have to touch upon, I found that a tax practitioner needs to have at least a basic knowledge of more than 75 laws. Basic at least. What is that law? You start with charitable. The recent issue, what you must have faced, if your clients were having the trust relating matters, you have to go to the Trust Act, Maharashtra Public Trust Act. Similarly, if you go upon partnership, you need to have understand of partnership law. Limitation Act, General Clauses Act. If you have any shipping company, you have to see shipping laws. Within that, there are 5 to 6 laws, basic laws, which you have to deal with. If you are touching upon capital gain, again, transfer of property at specific relief act, RERA, MOFA, etc. Also, you may have to touch redevelopment related issues is there. So if you go upon, there is an endless thing. I just mentioned 75 because probably I was able to see. Maybe at times you might have to go beyond this also. So the correlation or the interplay amongst these laws and income tax is very much there, and as a practitioner, whenever the matter comes, at least you should have a basic knowledge about that particular law. Because it might happen that if you don't inform the officer concerned, he may understand the law very differently and he starts applying. And many a times, small issues crop up and it becomes a matter of litigation, and ultimately it is settled at a very higher forum, tribunal, high court, or maybe Supreme Court. A classic example of this I will give you is section 80 IB 10. 80 IB 10 was a provision which was brought in under the Income Tax Act to give benefit to developers in regards to the profit which is generated from a particular project. There were certain conditions laid down. Now the conditions which were laid down, whatever the legislator who were draftsmen understood, and they gave certain condition to it regarding commencement, regarding completion, regarding the area, regarding the size of the each unit, etc. They put the condition. But this condition, whatever they have put, doesn't synchronize with the state laws. And you understand, every state has their own laws. For example, here we have a position in Mumbai of having an occupation certificate. You may not find this concept applicable to any other state. Completion certificate is there, but not necessarily an occupation certificate. Completion involves that it is an occupation. So this similar sort of situations are there. Redevelopment, if you talk about, cities are having these concepts of redevelopment. But if you go to smaller cities, two-tier cities, you will not have these sort of concepts. Now in the faceless regime, you understand you are having a redevelopment project wherein you have got certain additional area pursuant to the agreement, whatever you have entered, your society has entered, and thereafter PAAA agreement you have entered, and you got certain additional area. In such a concept, if your assessing officer, which you don't know in a faceless regime, but if he's sitting at a different location, at Chandigarh or somewhere, or he's sitting in Patna, then how he will understand your concept? So it is very necessary that you understand this concept and at least have a brief background, and you mention under which relevant act you have got this particular benefit, or what are the provision under which you have applied and the society has got this redevelopment done, and how this concept has an application to the Income Tax Act. So these are some complex issues which arises. We may not be able to touch upon everything, as I said. What I will do, I will touch upon certain issues which have a far-reaching impact, and in our day-to-day practice, we come across these types of issues. I will touch upon those issues. In case you have anything specific, you may put across, and I will try to deal. In case I have understood, I will try to touch upon those issues. Let me start with Companies Act. As I said, there are many issues. I will try to touch upon some specific issues out of it. So one of the point, what I have seen, you might have heard a department which is called SFIO, Serious Fraud Investigation, right? So under the 212 Companies Act, 2013, which deals with investigation into the affairs of the company. So whenever there is a serious fraud within the company, and when we talk about fraud, these frauds are relating to financial frauds, as well as it has potential of violation of corporate laws, various other corporate laws. In such a situation, this particular department of the government can invoke an investigation into the affairs of the company. When this investigation is taken up under section 212, it will deal with doing the investigation. If they find a particular fraud or financial irregularity, they may also register a complaint against you. There is possibility of attachment, and further prosecution and penalty also are the provisions, and these are the powers which are given to these officers. A question also arises that when these types of investigation is taken up, how the role of a chartered accountant or the auditors will be involved in this. Because it is a financial fraud, as an auditor you are required to report certain types of transaction in your audit report, and for any reason you have missed, the department shall call you upon and may ask you the explanation for the same. So it is very necessary that when you are doing an audit of a company, and if there are certain transactions which you find that this is above the basic criteria or the something wrong has been done, then it is necessary for you to put a necessary qualification. And you also maintain the records of these audits. Let me share you this with a live example. Yes, Sharad bhai. Let me share you with this with a live example. There was a case at Pune where an auditor had done an audit of a company which was involved in certain transactions which were termed by the investigating agency as a chit fund type of transaction, where you start with the bottom layer and the pyramid is made. Ultimately, the asset is not equal to the amount of investment or deposit what the company had collected. These were the type of transactions which were involved. Some investigation started. Ultimately, the company, the management, etc., they were arrested. They were prosecuted also by almost all the agencies, including CBI, ED, police, EOW, everyone got involved. But in whole of this process, the chartered accountant was also got involved. And not only that, whatever had happened in the criminal proceeding, the institute also initiated a disciplinary proceeding. Now, you start correlating, or the interplay is there, you start putting it in your mind, that how that interplay now start. The company has started, now the investigation, and now the chartered accountant is also involved. Apart from this, income tax was also there, but income tax was as referring to the company, not. But the consequences on the chartered accountant was that the disciplinary proceedings started. Now, as you know, our system of criminal law, the matter will never get concluded there. But as far as the disciplinary proceeding is concerned by the institute, it started proceeding, because they will not wait till the end of that proceeding. So it started proceeding, charges were also framed, and ultimately the matter reached to the final conclusion where your final arguments, etc. was there. There was a stage where we had to cross-examine the special auditor also, a very prominent, I will not like to name it, but a very prominent firm who does the special audit was involved. And when this matter came up to us, we said that we will like to cross-examine. And they said that the first time somebody is asking for a cross-examination of special auditor, he said, no, we will like to cross-examine, because your whole basis of your disciplinary proceeding is based on the special audit report. And the assessing officer has blindly, if you have come across a case where a special audit is done, the assessing officer blindly refers to the finding and conclusion of the special auditor to come to this. On that basis, they ultimately agreed that yes, cross-examination. We put few questions, and one of the important question was put across to the special auditor, that had you in your whole report when you were preparing, had you ever called the auditor to put him any question on the discrepancy what you have listed out? The answer was no, and that was more than enough for us to come out of the matter. Ultimately, the matter was argued, everything was there. As I said, the magnitude of the matter was running in thousands of crores and so many investigations. Our task was to see that the chartered accountant doesn't have to lose his certificate. The task was not to see the minimum this. Ultimately, we were able to go through the matter with a 6 months ban, what is there. We were able to come out of this matter. So the consequences are very severe if you miss. Though we had many points to be put across, but ultimately this is how the matter got concluded. Yes, the criminal proceeding is there. There the matter is still on. It will take its own time, own number of years to proceed further. But this is one of the consequences, just I tried to highlight how things will impact. Deposits are there, loans are there. All this transaction, some mischief the management will play or the company will play. But as an auditor, if you miss your role to report the same in your audit report, consequences will follow under the Companies Act, and the Serious Fraud Investigation Department can invoke their powers to look into the affairs of the company. The powers they have to call for the information, document, record the statement, to examine and cross-examine person. They have the power also to seize and take control of the books of accounts, documents of the company and investigate in the same. Now these powers have been exercised suo motu by these officers, and there are circumstances where the government will direct this department to initiate the action on certain class of company or a particular company also. For example, in the case of Satyam, it was through the government that the investigation started. This department was formed specifically to look into these types of scams related issues, and therefore this department came into picture. So just taking a clue from this is one of the issue where these types of complexity can arise in your matter. So it is very necessary that whenever we do audit or we are dealing for the client, and if there is certain responsibility which is on us, we see that our responsibility, we make it very transparent and we maintain the documentation part of that, so that tomorrow some question arises, that issue we can deal with it. Let me go further to Black Money Act. There are many other provisions under the company law which has a consequential effects. I will not deal with because those are more of a procedural nature. There are judgments also in the context of share premium, valuation issue. Department many a times doubt that valuation what has been done for the company law purpose when it comes to the Income Tax Act. The courts have time and again said that this is a matter which is related to the affairs of the company, and the company is the best judge how to deal with, and we cannot look into it unless there is some specific violation which is pointed out under the company law. One cannot look into it. Similarly, they bring about wherever the share premium has been received, how the share premium has been utilized. And if there is a violation, they try to invoke section 68 subclause 2 of that, saying that you have not utilized the amount of share premium amount for the specific purpose, but you have utilized somewhere else, and they try to invoke under the Income Tax Act to make a disallowance or make an addition under section 68 or 69. So courts have held, look, you are as an income tax authority, you have no business to question upon the correctness of a particular report or evaluation which is made under a different law. Unless until there is under that particular law, the authorized competent authorities have questioned that particular transaction, you cannot sit over it and say, unless the act provides for that. So these are some few areas, but these are more of a procedural nature, and there is not much dispute on this. Now coming to the Black Money Act, let me deal with this particular legislation, Black Money Act. So Black Money Act came into force from 2015. So if you recollect, in 2014, just before the elections, there were a lot of hue and cry about the foreign undisclosed assets which were lying in the foreign countries, and this assets was required. Too many things are there. Prior to that, Ram Jethmalani had filed a case before the Supreme Court and had requested the Supreme Court that these matters is required to be investigated, because at that time Panama this reports had come out, certain then Swiss related reports had come out, prominent names were listed, those matters were discussed in Parliament, and therefore because of the pressure, because of the statements which were made, this act came into force, which was called as a Black Money Act. The purpose of this act was undisclosed foreign income and foreign assets which were belonging to resident Indian, which were rested in the foreign countries. These needs to be disclosed. As a resident, you are required to disclose. It doesn't matter that this asset or this income you have disclosed in the other country. What was required? That it has to be disclosed in the return in the country where you are a resident. Considering this particular legislation was brought in, it has its own working regarding levy of tax, levy of penalty, prosecution, seizure of the assets, etc. When this law came into force, prior to this, the return from assessment year 12-13 onwards, the return included a FA schedule, which required an assessee to disclose its foreign assets, its income, if any interest is there in any trust entity abroad, you require to disclose the same. If that was not disclosed, this was again subject to investigation, penalty, prosecution, etc. After the 2014 elections, which were won by the political party, they brought this particular legislation, and the whole purpose of this legislation was to see that whatever the amount which was lying abroad, that has to be brought in. I am not very sure how much amount has been brought in and how much amount has been done about. But yes, there were a lot of investigation done. I don't know about the prominent people who were named. You must have read the name in the newspaper about them. But many clients are there who are not in that name, and their names might have not been discussed in the parliament or in the newspaper. But prosecutions were launched on them. Penalties were also levied on them. Just to give a few examples, so there were cases where SSEs, though has earned the amount, received those amounts abroad, but they had missed or they have failed to disclose in their return. The question was that whether a direct penalty could be levied in such type of cases. Section 43 provides for levy of penalty on such type of transaction. There were various cases, favor, against, in which the tribunals have taken a view that penalty is under 43 of the Black Money Act is not an automatic provision, just you have missed to disclose this particular transaction in your FA schedule. A penalty is not automatic. But there are certain contrary decisions which says that no, once you had this asset, it was within your knowledge. You cannot take a plea that I missed or it was just a mistake or a negligence in not declaring or disclosing this particular asset. You are required by the law to make this disclosure and you have failed it, and therefore a penalty is levied. Ultimately, this matter was referred to a special bench at Mumbai. And before the special bench, a question of law was framed, whether the use of word may in section 43 of the Black Money Act should be construed as shall, and other words, whether imposition of penalty is mandatory once the requirement of 43 of the said act are satisfied. The discretion, whether the assessing officer has a discretion to impose the penalty or otherwise. This was the question of law which was raised before the special bench. Special bench, just for your knowledge of all the members, special bench is a bench which is constituted by the tribunal, where normally there is a division bench or a single bench. Single bench is a matter where it goes where the amount involved in dispute is less than 50 lakhs. All other matters goes to a division bench. A special bench is constituted by the president of the tribunal. When there are contradictory views or diversion of views, then a special bench is constituted, where normally a 3-member or a 5-member bench is assigned on the bench. So this question of law was assigned to this bench, and after hearing this matter, the court came to a conclusion that, look, the discretion is vested with the assessing officer to levy or not to levy penalty. Now, I will take a pause at this moment, and I will try to say that what is the other consequences when a FA schedule you have missed or whatever is there. One is the penalty, what we are discussing. The other consequences is prosecution. There are many cases where prosecution has been launched, which is pending before the magistrate court. There are cases where the accounts which were opened by the certain SSEs when they were at Singapore or they were in any other foreign country, and while returning they have just missed to close the account. Because there the banking system is that once you do not operate the account for a particular time, it is automatically closed, or you do it by way of an email and the accounts get closed. So many of them have missed whatever the dollars or amount is there, they have repatriated or used or finished, and some amount either is left in the bank account, which they appropriated towards the service charges, whatever is there, and they close these accounts. Now, in such type of cases also, people forget 5-6 years have passed, what to be done. But this information, because of the double taxation agreement and understanding between the government and of India as well as the other country, this information now very easily flows to our country, and from the main CBDT, it reaches to the jurisdictional assessing officer. So your assessing officer will very easily come to know what you have done abroad, what you have spent there, where your bank account is there, wherever you have been trustee, your interest is there, any company or any enterprises. All this information is very easily available to the officer. It is now at a click of button that they will get this information. They have to just write it and this information reaches on their table. So once this information is available and they find that you have not disclosed, a prosecution can be launched. A prosecution can be launched under the BMA as well as the Income Tax Act. In the Income Tax Act, section 277, if you have ever got a chance to read, if you have missed or you have wrongly stated in any statement, verification, under the Act or the rules, you are liable to be prosecuted under section 277 of the Income Tax Act. Now again, you are liable for penalty, etc. in the BMA. The other consequences is 277 under the Income Tax Act. I have few clients where both the proceedings are simultaneously going on. Before the magistrate court under section 277 of the income tax, at the same time under someone's mobile. Not my client. You can take it. It might be from your home. You are late. So as I said, the consequences is just not under the relevant law that we were discussing under the black money, but the consequences also come under the Income Tax Act. And many times this unwanted litigation and unwanted pressure is there. And by the time it is before the income tax authority, you are expert, you will handle it, you will brief, but when the matter reaches the magistrate court, the whole thing changes its color. The moment you ask your client, the summons have been received, you have to go there and take a bail, the whole thing changes for the client. So you need to understand, and once your case is reported there and you have sought bail, the other consequences of this come. I have jumped from black money to income tax, let me jump further. Now once your case has been registered there, you seek a bail, the other consequences will follow whenever you have to renew your passport, apply for visa. All this information you have to declare. You have to take a permission from the magistrate court once your passport expires. When you go for renewal, if you have done recently, you will come to know there is a column which asks, is there any criminal proceeding which is pending against you? This information, because of the technology which is Singh now, your police station, nearest police station will also come to know that there is a case which is pending against you. This recent finance bill has reduced the sentence of various offences from 7 years to 3 years. But the cases of the earlier period were beyond 3 years, 7 years, also imprisonment and fine, etc. were there. So therefore, those are offences which are bailable, but these are cognizable offences. And therefore, a bail is required to be taken from the magistrate, because there is no remand which is called for by the department. Therefore, bail is a matter of right, where you go, you have to apply for a regular bail and you get the bail. There is no problem in that. But all these factors come into picture. Now, once a criminal proceeding is initiated against the particular individual, he might be a director. What are the consequences if a director, a criminal prosecution goes in the audit report, there is certain reportings which are there. If you are a director in a public limited company, there are certain disclosures. So these are the connecting consequences which will flow out. So many times when these types of investigation or these types of issues are there, a person who is holding some prominent position in public profile have to be very careful. And as a professional, when you are advising your client, you should take care. The client will simply say, I will have not disclosed to my chartered accountant because I never felt it is required to be disclosed. That was 5 years back I had an account, which my son or son-in-law or somebody was looking into it. Some dollars were left, I just left that account. But the consequences is grave. And then here the officers will not understand. But to your rescue, this is the special bench decision which is rendered by the Mumbai Special Bench just in the October 2025 by name Vinil Venugopal versus DIT, which is reported in Taxman 179 taxman.com 618. It is easily available on Taxman. Just on a click of a button, you will get this particular decision. So as far as this issue is concerned, under the Black Money Act, as far as levy of penalty is concerned, yes, there is a relief which is given, which says that the discretion is vested with the assessing officer to decide whether to levy penalty or not to levy penalty. But one should understand the consequences of this law is far-reaching, especially if you are having a client who is a director in a public limited company, who is trustee in some public charitable trust, holding a public office. You have to be careful. If these types of issue you find it while filing their return of income, see that the correct disclosures are made in the return. Otherwise, the consequences are grave, which may lead unnecessary to litigation. And ultimately, what will happen, we don't know, because these matters have not seen, none of these matters have reached to the final conclusion. They are still in the midway, but these are the consequences which one has to go through it. Yes. See, you are saying here there is no revenue loss, but you understand if there is an amount which is there, which is lying, and it is not brought here in India, the purpose of this legislation will be lost. The purpose of this legislation is what? To get hold of the income or the asset, which as a resident, you were required to disclose in the country and you would be liable for paying taxes. Now at the first threshold, if you will say I have not disclosed for blah blah reason, how the government will come to know about it? The whole purpose of this legislation will be lost. The purpose for which it has been brought in will be lost. You need to understand many a times when these issues come, you need not go into the details of all the provisions of the act. But it is very easy whenever you pick up a bare act. The preamble of that act is there on the initial first page. Just go read that. You will understand what is the objective of that act. If the objective of the act you are not able to touch upon, it will be very difficult to comply with that particular law. I understand there are so many legislation what you are dealing, and income tax, you are the master of this law, which itself is so complex. And then I am asking you to read other laws also. You might be saying in your mind what he is saying. Income tax act अभी समझ में आया, settle हुआ, तब तक change हो गया. Change होते होते जो पुराना law था, उसमें भी amendment कर डाला retrospectively. नया लॉ तो लाए, जब पुराना खत्म हो रहा है 31 मार्च को, उसमें भी अभी 10-15 दिन पहले आया, अमेंडमेंट हो गया retrospectively. So whatever is there, this is something which you need to keep in mind. Whenever you come across, then you have to be careful. Otherwise, unwanted litigation, unwanted consequences will follow. Going further, let me, as we are dealt with black money, let me deal with some provision, something on Benami law. Now, Benami law is basically related to certain Benami transaction. A transaction where a person has derived certain benefit without any consideration. There are certain exceptions provided which are basically related to relatives, partners in a partnership firm, directors or person in relation to fiduciary capacity. So they are exempt from certain type of class of transaction. A classic example let me take, because I was just referred a matter from Borivali itself, and I was very surprised that still these things are going on. A person had lent his bank account to someone and he did his transaction. The gentleman probably was from this area or somewhere, but again, I am just thinking, these transactions I used to find when I was with my senior. At that time, these transactions used to happen. But today also, if somebody is doing, I find he is very foolish, or I don't know what he is greedy or whatever is there. But again, he is lending his bank account to someone and he is using that bank account. He has given power of attorney also, and that person is using his bank account to bringing income, diverting income. Ultimately, few crores of rupees transactions have been done. At the end of the day, he files his return, he doesn't disclose that bank account. Income tax department obviously comes to know. Income tax department say, what is the debit, credit, whatever is higher, I will make the addition. Now he's taking a plea saying that, no, this is not my transaction. See, everything is there, very clear. I had assigned this to Mr. XYZ and he has done the transaction, he owns it. Whatever will happen, the faith in the income tax addition is made under section 68. Total addition, 115 double BE, tax rate is 90%, penalty will come. Almost he will be ending up paying more than the amount what is involved. But his case is very simple, I have not done this. Why me? There is a debit, person has brought in, there is a credit, person have taken it, where I have to be responsible. Apart from whatever has happened, now that person also has been issued a notice under the Benami law. As said that you have lent this amount, you have given this transaction, so why not a notice under the Benami law should also be issued against you? Because this is something where you are lending your name to someone. It is a case of also a misrepresentation. Somebody is doing a transaction, you are helping somebody to launder his money. Now there are two notices, income tax that is done, section 68, 69, all that will be there. Benami has come. Why not PMLA should also come? If it comes to know that even one or two transaction which has come is from a person who has this proceeds of crime, so you are allowing your bank to allow that person to launder his money. Why not PMLA should come in picture also? It is just a matter of time where this PMLA notice will also come. When a person is arrested under PMLA, it is not a matter of right, you don't get a bail easily, because it is again authorities which are handling enforcement directorate, they are handling the PMLA department. So this is another consequences which will flow, PMLA under the PMLA law. So this is just an example which I have given. Now let's take another case of bogus purchases. In bogus purchase, just one second. So under the bogus purchases also, same nature of transaction, same transaction which is there. Somebody may have allowed bogus purchases to be done, made. Ultimately it has come to the knowledge that this is not a purchase. There are no, except a banking channel, the actual movement of good is not proved. The actual utilization of the goods is not proved. You are not into the business, but you have taken the product. You are dealing in iron and steel and you are taking a textile product. Or you have taken a pharmacy product. In such type of cases, why not Benami law should be applied, or a PMLA law should also be applied if it comes to know that the earlier person has done this transaction to launder his proceeds of crime. These offenses which are there falls in Schedule 2. And when it falls within Schedule 2, these are not compoundable offense also, unless the Act specifically provides it to be compounding. You must have understood or heard, under the Income Tax Act, there is a compounding proceedings which are there, where after the prosecution is initiated or before that, or even if it is in the process, as per the guidelines which are laid down, you can go and compound the particular offense. There are certain compounding fees which are required to be paid, and once you have paid that, this is compoundable. In cases of bogus purchase, clients, when this prosecution is launched, the client said that we are ready to pay the tax, we are ready to pay the penalty, and then the prosecution will be closed. And then I have to explain that, no, you have to pay one more fees. That is called compounding fees. That is, it is over and above penalty and tax also. Well, yes, तो उसमें तो पूरा खत्म हो जाएगा. So that is the consequences. Apart from my fees, there is no reservation for that. So these are the certain consequences which are there. Because the subject was assigned to me was so this that I thought that why they have assigned me this subject, they want to threaten the audience or what they want to do. So I am very careful when I am dealing with this. I am trying to be as minimum I can point out. I am not going exceeding that amount. But these are certain consequences. I just want to highlight these are certain consequences, and that is why when we are dealing with these types of clients and when these types of cases are concerned, we have to be careful. So, bogus purchases, lending of your bank account, not disclosing these transactions in your return of income has these severe consequences, not only under the Income Tax Act where you end up paying the taxes. There are many clients I have seen, and you might have also come across, and they are very bold. They say, what will happen? Taxes they will ask. After my chartered accountant has told me that every 10 years there is a scheme which comes. And I will apply, my father had done that. I will also do it. You are unnecessarily scaring me. Then we have nothing further to say. So there are many intelligent people, intelligent and all of us, which they have a different flavor of their life. And we cannot change it, but we have to be careful in this process, because you understand that as income tax law, you must have that there is a provision for abatement of a particular in evasion of taxes. So even if it is found that we are involved in abating a particular transaction, then the department can rope in also as far as abatement is concerned. Under the other law, the similar type of provisions are there, where a professional can also be involved if they are able to found that they have abated. There are a lot of discussions about lawyers having a privilege and they will not be, but as a professional, chartered accountants are there. But you should understand that privilege is only a communication privilege. So for example, a person has come a crime, where he will go? He will not run to the police station next lane. He will first come to a lawyer and then he will disclose and then he will take and he will surrender or get the further things. So that communication what is there between a client and a lawyer, that is what is called a privilege communication. A privilege communication doesn't mean that as an advocate, I get involved in him, in the crime, and then I can say, no, I have a privilege. No, that is not a correct understanding. The privilege communication is a professional communication between the client and the advocate, which is exempt, because ultimately he has to disclose it and then only the advocate can defend him or go to the court or put certain things for him. So that is what is called privilege. Otherwise, a lawyer can also be prosecuted. If you must have read in newspapers, some very prominent senior lawyers of Supreme Court were issued notice from ED. And the only reason was they had given certain written opinion about certain transaction. Ultimately, the matter was different. They were one of the topmost lawyers practicing in Supreme Court. It came to the knowledge of the judges. Matters were put up against by the bar, etc. Things went in a different way. But this privilege is not available to all of us sitting in Borivali. So we should understand how these things will move around if someone is caught in this transaction. So you have to be very careful. I always say that as a professional, whenever we are dealing with the clients, we have to be careful while communicating with them, while sending any mails, etc. We have to be careful. We just don't know when the client may ditch us or may stab us back. So this is as far as the Benami law is concerned. The prominent cases are what I feel is the bogus purchases, which you all know. These are the cases where easily this provision can be invoked by these authorities. Transactions, one second. Yes, so I have touched upon Benami, and I am just saying, to be very fair, I have just touched upon these provisions. There might be many other complexities, many other examples which might be there. I am touching upon bogus purchases, bank account. You will come across transactions which are involving property dealings, which are having property dealings. The amount is being given by X firm, the amount is circulated from 2 or different bank accounts, Thereafter, it reaches the company who is investing in a particular property. So these types of transaction will also come under the cloud, under the Benami transaction, if the department is able to prove how this money trail has come and which has led to purchase of that particular property. Money laundering is another area where the ones, yes, money laundering is another area where the courts are concerned. The consequences of all these transactions, what we have understood under the income tax and the ultimately why it is done. It is ultimately done to launder the black money. So PMLA doesn't deal only with black money, but it deals with proceeds of crime. What is proceeds of crime? Anything which is an offense under the Schedule 2 is a proceeds of crime. So if I have done something wrong under the Income Tax Act, one has to see whether it's fall in Schedule 2. If yes, and I have done something, you may fall in this particular bracket. It is not necessary a proceeds of crime is only from a hawala transaction, or it is done through some criminal activity of drug trafficking, etc. It may involve certain other transaction also, and if you launder that money by allowing it to be used in your bank account, your company, your firm, you may be getting into this particular act. And as I said, this act is, though it mentions that the income is derived from a criminal activity, you will be able, you are not be exonerated from this merely by saying that, look, under the Income Tax Act, the department has levied so-and-so percentage and allowed me to go scot-free. There is a direct decision of Supreme Court under the Prevention of Corruption Act, where the SSC had taken a plea that, look, the income whatever is there, whatever you have come across, that this is the disproportionate asset amount, is ultimately accepted by the Income Tax Department, and my returns have been accepted by the Income Tax Department. So why you are prosecuting further? The court said that merely because your returns have been accepted by the Income Tax Department, it doesn't mean that the charges will be dropped as far as Prevention of Corruption Act is concerned. So it is not directly because under the one act you have been let go, you will be allowed to be going in the other act. This is what is under the criminal law. When we talk about income tax, we are not dealing with Evidence Act, we are not dealing with the old CRPC, IPC, etc. The new law which has come is more stricter as far as these evidence, etc. is concerned. The procedure things has been gone away, and now directly the court proceeds on the basis of the new act which requires direct evidence, and they proceeds faster as compared to under the old law. So merely because you have paid the taxes under the income tax or the other law, it doesn't mean that there will not be any prosecution. Example, under the sales tax, whenever this bogus purchase transaction used to happen, what used to happen that 2% or 4%, whatever the VAT or the sales tax authority used to levy, those parties were bogus, and we knew that those are bogus. And the client used to undertake that transaction understanding that 4% additional liability whenever it will come, I will pay. Still, I will be in a beneficial position. And then they used to enter that particular transaction. Understanding, yes, they will not pay the necessary taxes and we will pay on their behalf. And then used to argue that, look, that taxes also I have paid. Now, why you are levying tax here? But income tax says there is nothing doing, I am not concerned why you have done. In fact, your payment of taxes on their behalf shows that you are involved in that particular transaction. Because we have never issued any notices to that party, we have not taken any steps to prosecute them, take any civil or a criminal action against those parties. But we have paid the taxes on their behalf to close the matter as far as sales tax is concerned. So these types of consequences also come. You have to be very careful when you are writing a submission on behalf of a client, wherein he makes such type of claim that you pay this and we want to agree, a sort of an agreed assessment. Once you agree an assessment, it's very difficult if tomorrow department initiate penalty or such type of prosecution provisions against the SSC to take a contradictory stand. So one has to be careful when you are making these types of submission. So I was on the PMLA Act. So the PMLA Act is another law where you have to understand the legislative framework of this act is basically to avoid illegal finance activity. So wherever the illegal financial activities are there, the operation or the mechanism under which it has been created, the purpose of this act to stop it. So any transaction where a proceeds of crime is involved, this act will come into play. And it has nothing to do with what the income tax authority has done with your return of income, whether they have applied some percentage, they have deleted the addition on technical ground, they have no concern with it. Once they are able to pull the trail of the financial transaction, they will be they can proceed against you under the PMLA Act. In case you have any query or specific transaction is coming into your mind, so you can always put across. I will be happy to discuss that. Yes.
In case of a property transaction, chat with the WhatsApp is how far it is.
Okay. I will just answer your query. 1 second. So you are saying that addition based on an document or evidence which is collected from electronic device, which is nowadays WhatsApp. Everything is there on WhatsApp. Okay? Very dangerous app it is there. A lot of problem is there. You are talking about income tax. There are other problems also which is created. So there are certain good and against also. Strictly if you go about it, I will not answer that there cannot be an addition being made on the basis of a WhatsApp chat or a electronic information which is derived from a electronic, like your emails, your other social media. There is no bar under the law that you cannot make an addition. What the law requires, that whenever you produce any evidence, there are two types of evidence. Now, I am little transgressing in very technical, but I will not go into deep, otherwise you all will say that what he's started and where he has gone. So let me be very, very general. I will just touch upon. So there are two types of evidence, which is called primary and secondary. Primary evidence is the direct evidence, and the secondary evidence is the indirect evidence. For example, you are giving a Xerox. So it is called an indirect, a hearsay evidence. I heard Mr. So-and-so was saying like this. It is called a secondary evidence. So when you are giving a document from an electronic device, it is a secondary evidence. It requires to be supported by some authentication that yes, this is from my mobile, you have used this. Because I can simply say it has not been taken from my mobile, it has been planted on my mobile. There are cases where I have come across where these types of conversations or materials are put in your devices and thereafter it is extracted. So whenever these types of conversation takes place and department wants to use it, there is a provision called under the old Evidence Act 65B, which requires that whenever you produce this evidence, it has to be certified from the particular professional who is extracting this information and putting in a form of an evidence before the court of law. So if this certificate is not enclosed, these types of evidence are not admissible evidence in law. But again, this is very far technical. You cannot come by whatever I said that this addition cannot be made. Why? Strictly speaking, Evidence Act is not applicable to Income Tax Act except certain provisions of income tax. Certain provision of the relevant Evidence Act, except that the whole strict Evidence Act is not applicable to the income tax proceedings. If you go to the criminal law, certainly courts have relied on emails, on your WhatsApp for convicting the accused. But those are not only evidence. There are other circumstantial evidence also, other direct evidence also, which are used to ultimately come to the conclusion. There is a decision of Delhi Tribunal, probably you must have read, and therefore your question is coming, which is in the case of DCIT versus Ballar Marketing Private Limited, where the Delhi Tribunal has deleted the addition on the ground that the authenticated electronic evidence without a valid 65B certificate is not sustainable. Though there is a favorable decision, but I will not subscribe that based on this decision, you start your WhatsApp and don't do that. I have my own reservation on this decision. I will not say that merely because this decision is there cannot be any addition. Certainly, first thing what will a search happens, if you have seen, they will take your mobile, they will take your laptop, and they will extract the information. And once that information is available with them, they will do it. I have seen certain WhatsApp, basically they extract it, they even get it printed, and then they have that bunch with them, and then they will start questioning you on that. Thereafter, you have mentioned that you send me 1, you send me 2, you send it so-and-so bhai and so brother will come and take it. So all that is listed. Even if you delete your messages, that can be retrieved. They are able to retrieve your Apple phone, whatever you say, I have seen, they are able to crack the code and they are able to retrieve the information. I have myself seen those things. They are very easily able to crack and they will get all this information. So as far as your question is concerned, though there are some decisions here and there, but according to me, they can use that as a evidence against you. Okay? Now, I have dealt with the black money, I have touched upon Benami, some PMLA. I will just like to go on IBC. Now, let me take, I have dealt with some hardcore provision, let me deal with some general provisions also. So, IBC is a law, again, regarding insolvency proceedings against the companies. Once these proceedings have taken place, one of the important things which everyone is concerned is what about the tax liability. So once the tax liability is there and it is settled in the insolvency proceedings, one is saying that once the tax liability is settled, the department cannot recover anything further. Whatever claim has been made by the income tax department in the IBC proceeding, that is the end and that is the final, on the basis of which the IBC proceedings have been completed. So the courts have said that where a SSC company has informed that this proceedings has been taken place and the income tax department has come and put their claim, thereafter the proceedings, once the IBC proceedings are closed, the income tax cannot come and say, no, for the earlier year there was something additional which was there, or there was a demand which I failed to put it in my claim. No, once the matter is closed, the whole proceeding is closed forever. Similarly, there are cases where when the new management comes in place, in the place of the old company, in such a situation, can a prosecution be continued? When a old company has gone along and new management comes, which is taking over the old company, in such a case, some old criminal proceeding is there, can it be continued? Answer is there, as far as the new management is concerned, the new company which is born after the IBC, against that, the prosecution cannot be continued. What can be continued is against the old directors, the old company which is there, but not against the new company. So one has to be very careful when you are dealing in IBC proceedings. You have to make your claim. There is a claim which has to be filed before the NCLT tribunal, which deals with your claim, exchange this information with various authorities, and thereafter an order is passed. You have to be very careful when you are putting forth your claim, what you are going to settle. Whatever is mentioned in your claim, that gets settled. Something which is not mentioned, you cannot add on by the either parties. Nor I can do it, nor the other side, it is income tax or any other creditors, they cannot do it. So one has to understand that once IBC proceedings has taken place, it is income tax authority, GST authority, or any other state authority. They cannot come and recover something which is not part of the IBC proceedings. Another point is there that once, I have already just touched upon this, that once a IBC proceedings has taken place and a resolution plan has been passed, the old company comes to an end. And literally it is the old company is no more in existence. Can the income tax department later on issue a 148 notice or some other revisionary proceedings or some assessment proceedings in relation to the old period, which is already a subject matter of IBC proceeding and it has been closed? The answer is no, they cannot do that. once the proceedings, IBC proceedings are closed, a resolution plan is filed, approved under the IBC, everything comes to an end. What has been done is everything starts new from that particular stage. And what the department can do it against that particular new company only, and not against the old company, except there is some criminal prosecution or something which has not been subject matter of settlement and it is independently going on, that can be done. Also, one of the point what you need to take care, when these claims are there, loans, for example, loans are settled, we make a claim before the IBC that under 41(1), whatever the loans we have not to pay or we are settling it, for example, a 1 crore loan is there, you want to settle it for 25 lakhs and it is settled as per the resolution plan. In such a situation, what happens to the balance amount, whether it is liable to be taxed or not? Under the simple transaction, it will come in play and 41(1) will be applied. But you pass this, put this claim before in the resolution plan, and the resolution plan, if the order comes that these are the claims which can be looked into or considered by the income tax authorities, then in such a situation, can the department invoke 41(1) or not? Any answers? They cannot, even though the order says that it may be considered, it is not mentioning it should be allowed. So how it will be considered? Considered. But what about the benefit what you have taken away? So what you are saying is that once the claim is settled and the matter is closed, then you cannot make a fresh claim on that, and the department cannot invoke that to say that it will be liable to be taxed. But what if the order doesn't specify specifically on this particular issue? In that case, what will happen? Your claim is there, but the order doesn't speak about it. The order doesn't answer that. The court said your claim is there, but I will not, that income tax department has to look into it. In that situation, can they invoke? Okay. So I may have a difference of opinion here with you, sir. I feel that once the order is silent, whether it is allowing your claim or not, maybe your claim you have mentioned in your claim plan, in the plan, resolution plan you have mentioned, but if the order is silent, the department may invoke and say that, look, this resolution plan doesn't deal with, your claim might be there, but it doesn't deal with that. It doesn't give that, yes, this has to be allowed or this has not to be allowed. In such a situation, the department may invoke a provision and say that you have got a benefit and therefore I will invoke 41(1). So there is a gray area, what I feel. I agree with you, what you have said, but I feel there is a gray area because earlier when the resolution plan used to be put forth and it used to be approved, the whole plan used to be specifically dealt as a part of the order. But nowadays what the orders are coming, they are not dealing in such a manner. They specifically allow whatever they want to allow in the order and rest is just left out. So that is a gray area which you need to take care when your plan is being approved and a plan has been passed, because the consequences may flow accordingly. Yes. No, so once you inform the department and the department accepts your objects, see what the department will do once you inform, the liquidator will inform. Once the liquidator informs, the department either will object or will agree or will disagree. On the basis of whatever the liquidator informs, the IBC will ultimately pass a order. That order should contain something on that particular issue. If the order is silent, then the gray area, the dispute arises. Earlier, when this claim used to be made, you might have read in some decisions or in the newspaper, IBC proceedings are being used by many people just to get a benefit of settling the matters, getting the tax benefit, which is not the intention of IBC proceedings. That is not the intention at all of the IBC proceedings. But it has been used for that purpose. So therefore, what now they have also understood and they have said, we will not decide these issues. We will leave these issues. If your claim is there, you put forth before the income tax authority, they will consider your claim. What is mentioned there, they will consider the claim. They don't say the word allow. So earlier, before IFZ, when we used to go to BIFR, those proceeding, we used to specifically ask for allow this particular claim. And they used to allow it or disallow it, or they used to reduce it, or they used to give a waiver of interest. So we used to ask waiver of so-and-so, so-and-so, so-and-so proceedings, so-and-so sections. It should be waived, it should not be applicable to us. And that used to be allowed, and that is how we used to get the benefit of it. So these are the few areas as far as the IBC is concerned. Let's come to GST. My understanding and my knowledge in GST is very limited as compared to what you guys have. So if something is there, please add on that. So as far as GST is concerned, now the audit report, whatever is prepared, and your return which is there, your GST turnover and your income tax turnover, if there is a mismatch, the income tax authorities, the first question they will ask you that kindly match your turnover as compared to the GST return and the income tax return. If there is any issue in relation to the taxes which you have paid under that particular law, GST, and if it is not matching again here, the question or dispute will arise. If there is some information under the GST survey, search, or in the assessment which has taken place, it will have a direct impact on your income tax proceeding. The whole bogus purchases is based on GST information. So there is nothing much for me to say. A proceeding which has taken place under the another law will have a direct impact. I was at some seminar and I was in a middle of some officers, and they say that they have a specific department whose just work is to do data mining. And the data mining is at such an extent that it is unbelievable, it is beyond our imagination also. They have so much data about us that you cannot even imagine that. The process is that they have a very large chunk of information. And now to distribute that information is their difficult task. And even if they distribute this information, practically an officer to take that information, issue the notice and do the further thing is again a difficult task. But they have this information. In a minute of time, if they pick up an issue and you give a contrary reply, they can bring the whole information and they will put it across and they will show, see, this is there. You will not put it, your client may not inform you, but the officer will have all this information. A very simple example, sale of agricultural land. The moment an agricultural land is sold, the SSC will come, it is exempt from taxation. The officer, the moment you say and before you could say that your land was cultivated or not, he will have a picture. And he will say, see, this land was barren in 2 years back. And thereafter this land was again barren and nothing was grown. He has that much capacity to get this information and place it. I have seen this type of things in the assessment order where they have put this picture. So you have to be very careful when you are making any sort of claim. GST, another answer, supply. You will give the number of some truck or this. Ultimately, they are able to find that it is not a truck, it was an auto, or it was a two-wheeler. These are practical examples which at least I have seen across, that these information are mentioned that this information is there. Now because of e-way bill is coming, there are intelligent people in that also they are able to break through and bid. But the income tax department is again one step ahead. And they are able to find out, no, actually the truck was moving in the particular area only. What was there inside is a difference. So what I am trying to point out, that what we think right now, the department is 10 times ahead of us. The client might be smarter, but department is 10 times much smarter than us. So we have to keep these factors in mind when we are dealing with these issues and when the client just comes with a very general information and just say that, yes, this is there. As I gave you the classic example of agricultural land, they will only show you 712 extract and they will say it is an agricultural land and therefore it is exempt. That is not the provision. You have to show an agricultural activity. And if he is not able to show, department will certainly be able to show that there was no agricultural, no cultivation which had taken place on this land since last few years. And that is the end, because now he will not only disallow, but he will say that you have produced false evidence, you have given fabricated documents to making this claim, penalty, etc. is standing and you have to face that. So when these types of complex issues is there, you have to be little careful when you are putting across these things. So I have just touched upon these few laws. If anything specific is there, I will be happy to share with you. When we come to Limitation Act also, after COVID, you might have understand TOLA has come, the Supreme Court orders was there. So when you come to the Limitation Act also, you have to think that in various parts of our tax proceedings, Limitation Act is there. Limitation Act is very simple. Which date from where we have to take the particular date for counting the limitation. The General Clauses Act says that the limitation has to be counted from the date on which the order is communicated, unless it provides a different date. For example, if the Act provides that it should be from the date of the order, can we say simply that the date of order has to be accepted? Courts have interpreted such type of provision under different legislation and say that you have to read the date of the order along with the communication date. So unless and until it is communicated, your limitation will not start. Secondly, when you take about a limitation, if your limitation is expiring on Sunday or a public holiday, then what is the date? As per the Limitation Act, it is the next working day. It will not go back. It is the next working, which you will not find under income tax or the GST or any other fiscal legislation. That will be borrowed from you under the Limitation Act. If it is falling on a public holiday, it is on 2nd October, it will be the next working day which is coming. So this is also a Limitation Act, has its own flavor. At many places, this Limitation Act saves you the time when your proceedings will start or it will end. Another very interesting thing, a debt is there. 3 years has passed. The time for recovery is over, but in your income tax return, you have shown this particular claim. Department will say, 3 saal ho gaya, it is not recoverable. Why not I should tax it now? The other side is also showing his in balance sheet. For whatever reason, he's showing it, but he's not paying you. And you catch hold of his balance sheet from somewhere. Will your limitation will revive? Answer is yes. A debt which is acknowledged by the other side gives you a fresh date of limitation. Now this is not very helpful under the income tax, except when the department wants to invoke 41(1) or a balancing charge and trying to tax that amount, that no, what time ho gaya, now it is not recoverable, the other party is not confirming, not giving any letters also, we are issuing 133(6) notice and we want to tax this amount. We are saying no, we are acknowledging his debt, but we don't have his balance sheet. In such a situation, if you catch hold of his balance sheet and you say that he is acknowledging my debt, your limitation not only for the getting saved from 41(1), but under the general law, you will be entitled to sue that party on the basis of that acknowledgement, and your limitation will get a fresh life of 3 years. From the date on which he acknowledges your debt, from that date you will get a fresh life of 3 years. Now, some people may say that, but when you will explain this to your client will understand what your knowledge is there and how you are able to save his, whatever the amount is there, amount which is involved. So these are the few very interesting point on limitation. Similarly, when a person has expired, for example, a person has expired and you are not able to fulfill certain requirement of filing the return of income, or in a case of a auditor not being able to provide you the audit in time because he was not well, etc. In such a situation, can you go and claim that the limitation for this should be extended? Yes, there are provisions. Under the Income Tax Act, 119 is a provision which extends the limitation, 119 to subclause B, which provides that the CBDT has power to extend the limitation period in a case where your claim, your refund, or any such rights, the time limit has expired. You can apply to the board and get your extension done. The only requirement is that you have to give a reasonable cause, a reasonable and sufficient reason for that. Friends, how much time I have, or 5-10 minutes? Yes. Yeah, we all have to go home. I have bored you too long, and I hope I have not scared you on this. The purpose was not this, just to update you with these laws. And in this process, I have also just touched upon and understood this. So, friend, like this, section 68, 69, the wordings of those sections are changed over the time. Source of source, earlier we used to argue that source is not required to be proved. But now the provision itself has said that source of source is required to be proved. When we go source of source to be proved, company law comes into picture. The moment company law comes into picture, the trail of the transaction is required to be disclosed. And once that trail is there, and once the department catch hold of that, the transaction comes within the parameters of these legislation. And wherever they find, they will invoke this legislation. Initially, I also talked about these few hardcore provisions which are there, which dealing with black money, laundering of money, binami transaction. You have to be very careful when you are dealing with these issues. If you are doing a bank audit, you have to understand certain RBI provisions when you are dealing with a bank audit or bank related cases. The Depository Act. If you are dealing with a share transactions cases, you have to understand the security and SEBI law, how do they function. You have come across penny stock matters. Penny stock matter, a simple, what the order say, a standard order. Modus operandi of a particular company and his group companies, then they are mentioning that SEBI has taken the action. But how many times we have actually gone on the SEBI site and found that has the SEBI taken any action? If you have done that exercise, you will find in most of the cases, the SEBI has not taken any action. Or if it has taken the action, whether SAT has approved or it has deleted that addition, you need to go to those legislation, those laws, and find out ultimately what has happened. There is a saying that your left hand cannot decide something else and your right hand cannot decide something else. So the state law is like this. One hand of the government cannot say that transaction is valid, and the other hand of the state can say this law is invalid. So you have to maintain that balance. So whenever these types of cases come, you have to take few steps ahead to go and explain that no, that color of the transaction is different. The assessing officer has understood the transaction in a particular way, but that is not the whole way of looking. In a certain penny stock, when we argue, we show the bench that look, you are saying that this stock is penny, but today also at the click of the button, I can purchase this stock. So merely because I purchase this stock, I will be treated that I have dealt in a penny stock. There is no such concept of penny stock under the Act, nor there is such concept under the SEBI law. The definition has been created by the department through certain investigation, wherein they treat that a stock of a very low value doesn't have a financial background, has the stock has been increased by rigging. But if the rigging has been done by a group of people or a group of individuals, the broker or the management, can the person, a beneficiary of that, can be roped in? The answer court have said, including the high courts, that you cannot rope in the beneficiary merely because they have derived some benefit indirectly by entering that transaction, though they were not party in the collusion which was made by the broker or the group of individuals. So these are the few transactions where these types of different law has a color which you need to understand. Friends, as I said, I have just tried to touch upon 8 to 10 laws, but there are more than 75. When you come to transfer of property, let me take one more example. Transfer of property, you might have come across section 54, 54F exemptions. Now, in this case, date of allotment, there is always a dispute holding period from where we used to calculate. From the date of allotment, from the date of registration, from the date on which we got the possession. Now, this was under the old regime. Now, you please understand RERA is there. When RERA is there, you require certain transaction to be reported to the RERA authorities. The developer is required to be reporting the transaction in the RERA authorities. The date on which the building will start and the date on which the building will be completed is already there on the RERA portal. When you enter for a capital gain, your period of construction completion is already mentioned under 54, it is 2 years. If you are purchasing, it is 3 years. In such a scenario, how you will treat your transaction, under which head you are going to claim? There are decisions which says that if you are going and buying a under construction flat, it is not a case of a purchase. Now see RERA provision, can it be said that it is not a case of purchase, but actually I am constructing that? Can this interpretation be accepted? When RERA authority itself is treating the builder as somebody else and he is doing. So these are the few factors which you need to put in mind, and you have to reframe your transaction or give a color of that transaction in the correct way as far as the legislation is concerned. RERA is not something which the assessing officer might be aware, or he might be aware under that RERA what this transaction is there. But at the same time, you should also be aware that you cannot put forth a wrong claim or incorrect information to the income tax authority, because once he get your registered document, on the click of the button, he will get the report of the whole project. So these are the tenancy laws. Tenancy laws, when you are a tenant, you surrender the tenancy rights and you get a new property. You have to understand a tenant can never be an owner. So what happens that when you have a tenancy right, you have to surrender that right, and that right extinguishes on that day. And what you get is a new right from that. A tenant cannot become an owner. Tenancy, a person cannot have a better title than what he himself had. He cannot give somebody something better. So if you are a tenant, you will always remain a tenant. You will surrender your tenant and you will get a fresh. So these are the things what you need to understand whenever you are dealing with these types of, when a new legislation or something comes into it. Friends, thank you very much. Hope I have not bored you too much. The topic was very complex. And
Members, please be seated.
And I also had a hard time to understand, but whatever I could possibly gather, and another task was within a period of 1.5 to 2 hours, I had to deal with this subject. To best of my ability, whatever was there, I had put forth. I hope you must have appreciated this. Thank you very much, and for giving me a patient hearing. Thank you very much.
Thank you, sir. Members, any questions?
Yes, sir.
So you said the section 68 satisfy the source of source.
Yes.
And if that provision becomes applicable, then company laws comes into picture.
Yes.
Your saying of that the company law comes into picture means are you sticking to this deemed deposit provision?
Sorry, please.
Are you talking about the deemed deposit provision will come into picture?
Yes, deemed deposit provision will come into picture. That will certainly come, the source of source. Once they go into that, they will not stop at a particular level. See, prior to 2014, when this source of source was not there, how we used to explain a transaction? We used to say, I have borrowed this from Mr. X, and there is where the line used to get stopped. But now that is not there. You will say X, he will go from where X? He will go to Y, and thereafter that process will continue till the officer is not satisfied. And if he is able to lay down that whole trail, that is a matter of concern. So their ability to go beyond the source has given a different powers and their investigation a different color altogether. And they can go in deep, and this information now, as I explained to you, this information is now very freely available on the public domain. And it is in a very liquid form. You can, any officer at a click of the button can transact. In the family, if you are having gifts among yourself, or within the family you are circulating a transaction, the officer has the ability to just have the few key which he will take a permission from his additional or principal commissioner. There is, he has to take some permission if he want to access another return which is not within his jurisdiction. He has to take a permission. Once he takes the permission, he can access those returns also. And he will extract that information and place it before you. So all this ability and technology which is there gives a additional power to the officer to make this investigation. Yes, anything? Yes. See, the moment you say that I am surrendering something, let's take an example during demonetization. There were many people who went and surrendered, And what they did, they said, whatever you do, surrender or not,
Harsh,
I will tax it in at a different head. I will tax it at a higher rate of interest. That is what was the concern as far as the income tax department is concerned. Now, the moment you surrender, if the assessing officer stops there and he said, no, I will tax you under 115 BEE and I will take 60%. Thereafter, the second thing he will say that I will also levy penalty on that. Okay, he will levy penalty. Till there, one is satisfied. But it doesn't stop the assessing officer from further probing that from where this income has been generated. If it is part of your business or not. If you are not a part of your business, cannot he further make an investigation from where you have bought this amount, how it has come to your account? If he is able to do that, then certainly if he reaches at a point where he is able to say that this is a proceed of crime, on that day he will invoke that provision, not before that. For invoking PMLA, the first thing is required that it should be a proceeds of crime. And for doing that, he has the power to investigate. Directly he will not. He will investigate on that and thereafter he will invoke that. Yes.
yeah, any more questions?
The
Okay.
whole purpose of bringing out this legislation, we might have read this in newspapers or we might have heard these names in the seminars or program. But as a practitioner, if your client has come before you and you find certain things suspicious, just read this legislation once. Few provision of this legislation. This will give you a different insight while looking at a particular transaction, and probably when your client is explaining, you yourself will be able to gauge that no, actually the color of the transaction is something different. Yes, sir. Further reopening notice or something, as far as the old company is concerned. Yes. Or the assessment, to put in a simple way, the assessments which were involved, which are subject matter of closing the IBC proceedings. No, the strike off, I would say, will not apply on the same manner, because strike off is a different altogether. Just because the company is strike off, it doesn't mean that the existence of the company has gone forever. You can apply this concept in the case of an amalgamation or a merger. So you will find judgments, Supreme Court, Maruti Suzuki, which says that if the amalgamation has been taken place, the assessing officer had been informed, the assessing officer, it is within his knowledge, he cannot reopen that assessment in the name of the old company. What he can do, as far as the new company is concerned, he can do that. But he cannot initiate a proceeding in the name of the old company. A landmark decision of Supreme Court in the case of Maruti. There is a recent decision of Bombay High Court, which after considering Maruti as well as there are subsequent some decisions, they have rendered that yes, once the SEC has informed the officer that amalgamation has taken, he cannot issue a notice in the name of the old company. What he has to do, he should initiate it in the name of the new company. So we are talking about an amalgamation. So IBC and amalgamation are two different proceedings. But same will not apply as far as what you said is in the case of a striking off. And you should, whenever I am talking about this, you should understand section 179 also of Income Tax Act, which says that the department can proceed against a director towards its personal liability also in case certain things are proved. So again, that is an independent proceeding which he can initiate that, subject to the conditions of section 179. So here is that income tax officer will issue the notice to him. Probably you will not be able to prove, but the assessing officer will be able to show. So once you cast, then you have a right to say that I don't have the access to his financial. I will request you kindly issue 133(6) notice. So it is the department can invoke 131. So these are the powers which are vested with the income tax department to be exercised.
Okay.
Yeah. Anything else?
Thank you, sir, for such a wonderful session. Members, regarding our fees for the year 2026-27, detailed email will come to you by 1st of April. It will become. So what are the modes of payment? You can see from the email and pay the fees accordingly. As far as today's topic is concerned, sir has explained in a very, what you call, excellent and efficient manner. Now I request Sandeep Shah to propose a well-deserved vote of thanks.
Thank you, Vijay. On behalf of WIRC and Borivali Central Study Circle, I sincerely thank Advocate Ajay Singh for his time in accepting our invitation. Your comprehensive insights and the practical examples on various acts inter alia, Black Money Act, Corporate Laws, Benami Act, PMLA Act, Bogus Purchases, Money Laundering, IBC, Limitations Acts, etc. made the seminar highly engaging and informative. The way you address our queries and the concern was truly appreciated. Thank you, sir. Your contribution to today's seminar is truly appreciated. With this, I request all the members to extend a hearty vote of thanks to our speaker of the day, Advocate Ajay Singh. Good night. See you in the next seminar in the next coming year.
Members, please don't crowd the attendance. Go slowly and follow some basic